Okay. So, could you, let's get into a conversation about the sacking of CJ Justice Gertrude Torkonoo. We've been joined on the phone by Raji Musah Fuseini. He's a former member of parliament for the Tamale Central constituency and was ranking member of the Constitutional, Legal and Parliamentary Affairs Committee in Parliament. Musah Fuseini, good morning, and thank you very much for joining us.
Good morning, Winston and Kojo. Thank you for having me.
Great. So, I know you've monitored events since the sacking. You've heard the likes of Ayikwe to say she did nothing wrong. He says all these things are things she was entitled. Based on what you've seen as communication from the presidency to the Chief Justice, and based on what was determined as stated misbehavior, would you say that warranted the sacking of the Chief Justice?
First of all, we need to get everybody to understand that the architecture and design of Article 146 of the Constitution of Ghana 1992 was intended to protect justices of the Superior Court of Judicature and chairman of the and chairman of regional tribunals.
Okay,
that's the first thing. So from Article 1461 to the last provision of that article are checks on the powers of the president, so that you can, and a capricious, willful president cannot at will remove a justice of the Superior Court of Judicature. And the Chief Justice is a justice of the Superior Court of Judicature. So you have institutional limitations on the exercise of that power. You have procedural limitations on the exercise of that power. And you have substantive limitations on that power. So, and I have said time and again that for you to understand the remit of Article 146 and what it was intended to do, you need to go back to the 1969 Constitution.
Okay.
It is the 1969 Constitution that established the Council of State and said that an individual in this country, a citizen of this country, who is dissatisfied with the way the Chief Justice or justices of the Superior Court of Judicature are going about their duty, and who thinks that their conduct falls within Article 1461, can invoke the authority and power of the president to subject that conduct to inquisition. So we must all understand that. And so it is important for anybody who is interested in safeguarding the rights of the justices of the Superior Court of Judicature and the independence of the judiciary to follow through the provisions of the Constitution and see whether the fidelity of the provisions of the Constitution have been given effect to or have been obeyed.
Have they been given effect to?
So let's track it.
Go ahead.
The Bar Association of the Republic of Ghana said in their first release that nothing untoward, they have not seen a breach of the provisions of the Article 146 of the 1992 Constitution. The Bar Council of England and Wales, in their long letter to the President demanding the restoration of the Chief Justice, have not pointed out one breach of the provisions of the 1992 Constitution, and particularly Article 146. The Commonwealth Lawyers Association, who joined the Bar Council of England and Wales, did not indicate or point out or state that Article 146 has been violated.
Okay.
Legal experts in this country are unanimous in saying that Article 146 has not been violated. The adequacy or otherwise of Article 146 will be a conversation on its own.
Okay.
But for now, we say that Article 146 has been followed through. The President has followed all the checks on his power, and he has, under Article 146(10), relieved the Chief Justice of her responsibilities as a Chief Justice and also a justice of the Superior Court of Adjudication.
Please hold on 1 minute for me. Hold on 1 minute for me, because we've been joined by Nana J. Bafour, who is Member of Parliament for Manhyia South and also a lawyer. Nana J. Bafour Awuah, good morning. Thank you very much for joining us.
Good morning, my brother. And
Great.
Thank you for having me.
Great. So now you've seen, I'm sure you've seen some of the reasons that led to the dismissal of Gertrude Torkonoo as Chief Justice and Justice of the Supreme Court. Based on what you've seen, would you say this is the right call?
My brother, we've had all the conversations on procedure and propriety of the complaints that were made against her prior to the decision coming out. And in my humble view, we've exhausted it. It is without a doubt that this is a predetermined conclusion. An answer was set long before the NDC came into power. And when they came into power, they set the question that would lead to the answer which was set before they came into power. In my view, very respectfully, whatever discussion we have is academic. All we can say now is what has happened is very unfortunate. Look, I heard my brother talk about the fact that no law has been breached. You may agree with him, you may disagree with him. I wish I could play a song of Daddy Lumba today, or request it to be played. There's a song, one of his gospel songs, was it why na otini? Why na otini? My brother, let's even make an attempt to judge the current system by the same principles, right? Sometimes, because of our relationship with some of the judges, our friendship with them, they are very careful not to say things. But look, in recent times, the acting Chief Justice was traveling. He issued notice that Justice Puaman has been appointed as an acting Chief Justice. You are an acting Chief Justice by reason of a constitutional sanction. Can you appoint another person to act in your stead simply because you are traveling? My brother, if we were to hold the standard so strict, nobody will qualify. Nobody. My brother, we have to be careful what we are doing.
But Nana, are standards not meant to be adhered to? We've set these standards, so why did we set them in the first place?
My brother, what are the standards? You know, there are various degrees of standards and their consequence for breach. I'm saying that in administrative work, it is so difficult for a person not to commit one or two errors in administrative work. If every single error is going to constitute a ground for removal, then nobody is safe. That is all I'm saying.
Okay, but let's look at it this way, for instance.
Wait, let me go on.
Okay, please go on.
Let me come in. Let me. Look, we are saying that today, the Chief Justice suggested names of justices for appointment to the Supreme Court, and that is a ground for her removal. My brother, it is a convention even in Ghana that the Bar Association suggests names to the President for appointment to the various courts, the High Court, the Supreme Court, and the Court of Appeal. Are we saying that the President, by accepting such suggestions, has misconducted himself? Is that what you are saying? That the Bar Association, we all know, suggests names for appointments to the various courts in Ghana. Are we saying that by the president, by accepting such suggestions, misconduct himself because he solely has the mandate to make those appointments? Brother, we need to be careful. Look, the Chief Justice is not perfect. It is not everything that she did whilst in office that we agree to. But we should be careful not to set precedent that is going to erode the gains that we have made as far as our democracy is concerned. I have always maintained that whatever she may have done that we dislike, we could have reformed the system to stop them from reoccurring rather than removing her. But if you remove her just to teach her a lesson and settle scores, in the future, people will put aside the law. Look, my brother, as for the law, you pass them, but there is always a way around the law. I'm telling you, and then you have judges who are friendly with an establishment, right? That would give the establishment the interpretation they want to support their cause. And so you may be removing Justice Torkonoo today. Tomorrow you think that you'll be tightening the bolt so that what you have done will not reoccur to whoever you are going to appoint. But I am saying that as a lawyer, very respectfully, there will always be a way around it. You understand? When we were in Ghana, when Dr. Ayeni challenged the appointment of Mr. Martinamidu as special prosecutor on the basis that he had gone past the age of 60, go and check what the Supreme Court said. Even in the face of what the Constitution says. So I am saying that there will always be a way around the law. And so if you dislike Justice Torkonoo and you remove her today on the grounds on which you have removed her, you may think that whoever you are going to appoint as a replacement, okay, that person, you are going to protect her or him with laws. But trust me, anybody determined to remove that person will do it. That is why I cited the example of the appointment of the acting Chief Justice of Justice Kwaman to act in his stead. Now look, if somebody comes in and he wants to take issues, the person is simply going to say, why did you accept to act? You acted in a manner which is unconstitutional. And then there will be people to give judicial or legal blessing to it.
Now, Bafour, briefly, Musah Fuseini made the point that he didn't think that any, law had been breached throughout the process. Is that something you would agree?
My brother, Article 146 is both procedural and substantive. Article 146. So whereas no procedure may have been breached, there may be issues with the substantive provisions of Article 146. My brother,
what are those issues that you see?
Misbehavior. What is stated misbehavior? What law has defined it? When a law says stated misbehavior, right, it speaks to express provisions regarding misbehavior, expressly defined. What law has expressly defined misbehavior? What law says that whatever grounds the Chief Justice, whatever the Chief Justice has done will constitute stated misbehavior?
Okay, please hold on. Let me bring in Musah Fuseini. Musah Fuseini, I mean, Bafour Awuah is raising questions about what constitutes stated misbehavior. I thought that was settled in the Charlotte Osei case.
that is. I think that Bafour, Honorable Nana Bafour Awuah, should go back and look at the law and procedure. First of all, if indeed the Chief Justice had once upon a time been traveling out of jurisdiction and directed Justice Fuama to act in his stead, that would have been a breach of the Constitution, a willful, underlined, willful breach of the Constitution, and that would have been unconstitutional, and that would have been misbehavior. Because the Constitution clearly states, in the absence of the Chief Justice, the person who is to act should be the most senior on the bench. The Constitution is clear on that. The Chief Justice has no discretion in that matter. So a wrongful exercise of discretion, Bafour Awuah, is a stated misconduct. I'm not privy to the facts of the case, but just taking it from what you have said, that would have constituted a stated misbehavior. Because the discretion would have been wrongly exercised. That's number two.
Okay. Well, brother,
number two, I've heard people argue, and that I think that is, let me hasten to add, no matter how emotional you feel about what has happened, that does not operate to displace the fine provisions of Article 146. No matter how emotional, or no matter your idiosyncrasies, it does not operate to derogate from the requirements of Article 146 of the Constitution. Now, stated misbehavior, and I've heard people argue that when the Chief Justice traveled with the husband on public resources, she was entitled to do so. And even if she was not entitled to do so, administratively, the Auditor General should have surcharged her. Surcharge arises out of unlawful, unpermitted expenditure. And so, if you argue that she ought to have been subjected to a surcharge, in fact, you are arguing on the principle of double agony. Because if she had been surcharged by the Auditor General, we don't know, I have not invested in the nitty-gritties of the matter because of the requirements of the matter being held in camera. I've invested my time and energy in the procedure. Now, if a person is surcharged for wrongful expenditure and the money is recovered, that is evidence in the case of a Chief Justice or Justice of the Superior Court of Judicature or Chairman of a regional tribunal, that will be evidence of stated misbehavior. And what is stated misbehavior? You cannot remove a Justice of the Superior Court of Judicature on general understanding of misbehavior. You must state stated misbehavior. You must state what the misbehavior is. You must state it. So that's why it is called stated misbehavior. You must state that misbehavior.
What are the elements? Okay. So
in the Charlotte case,
since we are all learning, Musah Fuseini,
yes.
What are the elements of stated misbehavior?
Well, so the 1969 Constitution should be a guide in this conversation.
Can you share them with us if you
For instance,
ready available? Yes.
A Justice of the Superior Court of Judicature is not, by the requirements of the Constitution, permitted to take to a podium and campaign for a political party. Is that not it?
Yes.
So if there is evidence of a Justice of a Superior Court of Judicature mounting a platform and campaigning for a political party, what is it?
Tell me.
It's stated misbehavior. The Constitution does not say that such a justice should not vote, and so all of them have parties they vote for. But Constitution forbids that person from mounting a platform and campaigning. You see? Now,
yes, but so
if a person,
so in this case, for instance,
if a justice of the Supreme Court of Judicature knows that in procuring tickets for her travel, she is not permitted to use public resources on a non-public officer. She's not. Your public institution can facilitate your travel, but the expenses of your travel must be borne, of that private person must be borne by you.
So
and
on that score,
his or her way.
On that score, Musah Fuseini, if you look at that, yes, while on official travels, you can go with your spouse and a family member. However, on private travels, you cannot do that. Now, the argument was that when she traveled officially, entitled to traveling with a spouse and a child or a family member, that she did not do, those savings made could be used on a private trip. The question would be, what has been lost to the state if she had the opportunity to use this and did not use it, and those savings are used in another trip? Has the state lost anything?
So, is it Kojo or Winston?
Winston here.
Winston.
Musah Fuseini.
Where in public practice do we defer the use of a right for another person? Where in public service?
Tell me.
There is nothing like that. There's nothing like that. So if you are supposed to travel with your spouse on an official visit, and the law, and I even have my doubts about that, the law permits you to travel with your spouse on public resources, and you decide that on that particular trip, you are not going to travel with your spouse. There is no savings made. It's gone. It's gone. You don't make savings.
Listen.
You see,
Listen.
What the Constitution and what Article 146 is intended to achieve is to prevent judicial impunity.
Okay. Please hold on. Let me bring Aneje Bafour Awuah into the conversation. Yes, Aneje, you want to make a point? Please go ahead.
My brother, firstly, my friend Mr. Musah Fuseini stated that I should go and check the law and procedure when I raised issues concerning stated misbehavior. From his submissions, he has failed to refer to any law that spells out behavior as far as the judiciary is concerned. My brother, you must be aware of what constitutes misbehavior well ahead of time. No law, you see, the law should not, is not the kind which is spelled out or which is generated, right, as and when the offense is committed. It is to be there in place so that everybody knows that if I do A, B, C, D, it will amount to stated misbehavior. It shouldn't be the case that it's after the fact that somebody will come and determine whether or not what you did amount to stated misbehavior. That is where the problem is. It leads to arbitrariness, which is what the Constitution seeks to prevent. Right? And it's exactly what has happened, that they are just taking advantage of slippages, very flimsy slippages by the Chief Justice. Mr. Musah Fuseini, as minister, cannot tell us that he led a perfect life. He can't say that he committed no error if the same standard is being used for the lives of Mr. Musah Fuseini.
Yeah, but Manhyia Bafour Awuah, are you saying that we should not aspire for a better society? We should not aspire to have standards because people are bound to make mistakes? There should be standards, shouldn't they?
My brother, that is what I'm saying. There should be standards. But the standard, the number one standard, is you setting rules in advance of breaches. And not that you would now come up with, you would now post the event, then decide whether or not it constitutes or it amounts to a ground for a removal. No, law doesn't work like that. Law does not work retroactively. It doesn't operate retrospectively. It should be well advanced of time. That's the position I'm making. That is the number one standard. In the absence of it, it will lead to arbitrariness, which is what we seek to prevent.
Okay.
Okay? And so, by all means, let's punish people. But let there be certainty, let there be standards where we all know that if I do A, B, C, D, right, it would amount to stated misbehavior. Okay? Now, we need to reform the system. But, my brother, let's be cautious in the manner in which we have handled this. I think that it is over. No matter how much we discuss it, it's not going to change anything. I think we should move ahead. The NDC, the first year of the NDC government is all done. The government has 3 years. The things that it promised us, let us begin to hold them to account. Right now, the Galamsey, it said that the MPP government ought to declare a state of emergency. 1 year, almost 1 year into its reign, has not declared a state of emergency. When the president came to Parliament, he said about 2 million Ghanaian youth were unemployed. Let's find out how the government is doing to get employed. Right, it's gaining strength as a city, which is fortunate. When it is better, it's good for all of us. Let's prove upon it. The escalated violent and conflict all over the country now. Now we should call on the government to step up to stabilize the situation and save human life. I think that the matter of the Chief Justice is done. It is fortunate. What this precedent means is that every justice of our court should be very cautious, because now they cannot be removed. They cannot be removed. Look, recently, in just for known to me media staples, right, was kept and denied bail for 2 weeks. Okay? In the future, that may constitute stated misbehavior or incompetence.
How?
It may. My brother, that is why I started my submission by drawing your attention that there will always be a way around the law. And that is why we have to be careful. If anybody wants to be mischief with the law, my brother, I'm telling you, there will always be a way. And that is why I stated that we have to be careful, because when you set the wrong principles or standards, look, we are all not safe.
All right.
Okay? And so be very careful with what we are doing. Okay. I was hoping that we would rather pursue a constitutional reform that would ensure that some things that we're not happy with, right, will be reformed and not reoccur. But if this is the way we need to go, then we have to all be careful.
Let me bring in Musah Fuseini at this point. As we wrap it all up, Raji Musah Fuseini, there were those who actually had argued that, and we're still learning, that yes, she's been dismissed as Chief Justice, but could have remained as Justice of the Supreme Court. I see that the presidency was clear, Chief Justice and Justice of the Supreme Court. There are those who say that is not clear, and so the president shouldn't have just concluded and say she can no longer be Justice of the Supreme Court. What's your position on that?
Well, I think that they have misread Article 146. The head note or the side note, depending on which constitution you have, titled Article 146 as a removal of justices of the Superior Court of Judicature, or regional chairman of regional tribunal. So that is settled. So the Article 146 or so provides a procedure for dealing with a petition involving the Chief Justice, because all other petitions involving justices of the Superior Court of Judicature and chairman of regional tribunal must be sent to the Chief Justice for the determination of prima facie. But when it comes to the Chief Justice, you are looking at another legal principle. Can she be a judge in her own cause? The framers of the Constitution says no. In that case, let's find a neutral body, a state body, acting in consultation with the president to determine whether or not the prima facie case. So that's procedural, like Bafour Awuah said. But let me hasten to say, Bafour Awuah, stated misbehavior has been applied under Article 146. It's not new. Lorocalamte is not new.
Okay.
You don't even read Lorocalamte.
Finally,
give you an idea of what constitutes stated misbehavior.
Misah Fuseini, finally.
Charlotte Osei, stated misbehavior was applied. It didn't just drop down.
Okay.
So we have an understanding of what constitutes stated misbehavior.
Now, finally, based on all that you've said, looking at the procedure and everything that has gone on to the final determination, and the precedent that you've talked about, would you say the right precedent has been set?
Well, Article 146 was intended to hold justices of the Superior Court of Judicature accountable, and also to enhance public confidence in the administration of justice or the judicial system. Article 146 and its antecedent provisions in the 1979 Constitution have not been exercised in terms of a Chief Justice. Has been exercised in terms of analogous independent constitutional bodies under the 1990
right
Constitution.
Precedent been set?
What I will say clearly is that Article 146 of the 1992 Constitution has now a new lease of life.
This is a yes or no, Raji Musah Fuseini. Has the right precedent been set?
The right precedent has been set. I just wanted you to understand the underlying thinking of Article 146 and not jump into conclusions of precedents. Okay? The underlying reason of Article 146 you must understand before you come to the conclusion that Article 146, the precedent has been set.
Okay. All right. Thank you very much, Raji Musah Fuseini. Thank you also, Manhyia Bafour Awuah.
Hello?
Yes, Manhyia, you want to make a point finally? Yes, go ahead.
Yes, let me make a point. One, you see, my brother couldn't confidently state whether the right precedent has been set.
He said it has been set.
So, my brother, look, Charlotte Osei, Madame Lorocalamte, they were all administrative decisions. You cannot use administrative decisions to say that the
call has been put on hold. Please wait.
Stated misbehavior has been developed. No, you cannot rely on administrative decisions. There ought to be judicial pronouncements on them. Until the judicial pronouncement, you cannot say that stated misbehavior has been defined or has been established, as to what constitutes stated misbehavior. That is entirely wrong. I don't think that position is accurate. Let me use that word. It is not accurate. As to whether or not it is the right precedent, posterity would judge us all. That is all I want to say.
Thank you very much, Manhyia Bafour Awuah, and you also heard from Raji Musah Fuseini.